It's true that Malam was issued after this order was entered, but the issue on appeal was clearly discussed, notwithstanding the fact that after it was entered, further case law has been issued discussing the specific legal standard and legal review that's applied to that decision.
But I guess I don't see where you say it was specifically discussed. I mean, saying the bank argued generally that the notice complies with the requirements of paragraph 22. How does this put the trial court on notice, especially pre-Malam, that this substantial compliance standard should govern the trial court's decision?
Well, I don't know that it puts the trial court on notice that substantial compliance per se is the standard. The case law dealing with substantial compliance came out after this decision was issued, but certainly the argument being made between the parties was whether the variation from the language of the mortgage warranted dismissal under paragraph 22. And once again, the trial court did write specifically in its ruling that it was dismissing the case because of the absence of the word sale from the language of the letter.
And before Malam came out, would that have been a correct decision under the law?
No, I believe even before Malam it would have been an incorrect decision. I'd specifically point to this court's decision in U.S. Bank versus Buskets, which was decided in 2014, which didn't discuss the standard of substantial compliance versus strict compliance, but in that case we had a challenge to a notice of default involving the exact same language as the letter in this case. Literally, it's verbatim the same letter, and the challenge in that case was that the letter was deficient because it stated that the lender would foreclose on the property without specifying that the foreclosure would be by judicial proceeding. And this court reversed that ruling, finding that the letter was sufficient, pointing out that in Florida all foreclosures are by judicial proceeding, and therefore stating that the lender would foreclose on the property was sufficient under paragraph 22. Now, clearly in that case, the language of the letter didn't precisely track the language of the mortgage, but this court held that that was not necessary in order for the letter to comply with paragraph 22. And here, the lender did respond in the motion for summary judgment, arguing that the letter did comply with paragraph 22. And I think the court's reasoning in Buskets is equally applicable in this case. Again, it's the same language. Just as all foreclosures in Florida involve a judicial proceeding, all foreclosures in Florida, if they're successful, involve a sale of the property in order to satisfy the outstanding amounts due on the loan. That's how a foreclosure works. So I believe that regardless of whether the court used the word substantial compliance, that is the standard that would apply, and the trial court's decision was wrong even under this court's precedent prior to the issuance of that ruling. And just one other point I would make with respect to substantial compliance, the letter in this case did also specifically encourage the borrowers to review the provisions of the note and mortgage, and the mortgage did in fact specifically refer to a sale. That would be one additional factor, I believe, that would support reversal in this case. The second ground warranting reversal is that the borrowers failed to establish any prejudice as a result of the variation in language. This and other appellate courts have stated that absent some prejudice, the breach of a condition precedent does not constitute a defense to the enforcement of an otherwise valid contract. Here, the borrowers made no argument in their summary judgment papers that they had suffered any prejudice as a result of the variation in language. In their answer brief, they assert that prejudice doesn't apply in the paragraph 22 context, but that's contrary to numerous cases we've cited in our briefing. In particular, I'd point to the 4th District's decision in Ortiz versus PNC Bank, where the argument was that the letter was deficient because it indicated that the borrowers had to file a separate court action in order to raise defenses to acceleration and foreclosure, rather than being able to raise defenses in the foreclosure action itself.
Did you argue prejudice at all below, even if arguably you raised the substantial compliance issue? Did you say the word prejudice at all?
No, prejudice was not argued in the summary judgment papers, Your Honor. Again, after the case law dealing with prejudice, most of the case law, there was some case law dealing with prejudice prior. I think the Fifth District's decision in Gorel was issued about 2 weeks before the trial court entered its order in this case. But again, courts have clarified that prejudice is a necessary requirement before a trial court can dismiss a case for failure to comply with paragraph 22. And with respect to Ortiz, I would just point out that the court held that because the borrowers in fact appeared in the foreclosure action and raised defenses, they clearly weren't misled into believing that they had to file a separate court action. And I believe that same rationale applies here. The borrowers clearly, on the face of the record, were not prejudiced. They weren't misled as to the consequences of failing to cure the default. They appeared in the foreclosure action and raised defenses, just as in Ortiz. And a sale of the foreclosure action, to the extent that they weren't advised that the foreclosure would specifically involve a sale doesn't occur until the end of the foreclosure process. They're clearly aware that a sale is going to occur if the foreclosure is successful. They'll be given notice of any sale well in advance as required by Florida law, and they'll also have the opportunity to raise defenses raise objections following the sale. So we would submit that because the letter in this case on its face does give all the information required by paragraph 22, and because the borrowers failed to establish prejudice, the order in this case is erroneous on its face and must be reversed. And
prejudice would require us to engage in fact-finding, though, wouldn't it, that the trial court never had the opportunity to engage in?
I don't believe so, Your Honor. I think the absence of prejudice is clear from the face of the record here. As I said, a sale, to the extent that the failure to advise the borrowers of a sale is even relevant, it only becomes relevant at the end of the foreclosure process. And in this case, the borrowers are clearly aware, I mean, on the face of their papers, they're aware that a sale will occur well in advance. And unless the court has any additional questions, I will reserve the remainder of my time for rebuttal.
Okay. Thank you.
Thank you.
May it please the court. I'm Mark Stubb, a counsel for Mr. and Mrs. Fairbanks. Your Honors, my opponent is asking this court to eviscerate paragraph 22 by judicial fiat based on arguments that were not preserved. That request should be rejected, and the order at bar should be affirmed. Let me start with preservation. It's very clear that the arguments that my opponent made here were not preserved. I appreciate Your Honor's questions to my opponent in that regard. Both of the key concepts that my opponent argues as a basis for reversal were clearly not argued below. They filed 2 different responses to each version of the summary judgment motion, including the final one that was adjudicated. The word prejudice was never mentioned. My opponent concedes that there's nothing in the record that establishes that the concept of prejudice was argued below at all. The lower court couldn't have gotten it wrong based on an argument that my opponent didn't even make. That is the very essence of preservation as set forth in Ailes versus Bohemi and its progeny.
But couldn't the trial court have gotten it wrong based on the applicable law?
Well,
I mean, if Deutsche Bank raised the issue of compliance, and whether there's been substantial compliance guides the trial court's judgment in determining whether compliance has occurred. And so, arguably, by raising the issue of compliance, they put the court on notice, and the court just applied the wrong standard.
I get what Your Honor's saying. This is how I was doing it, quite frankly. There's 2 issues. The first one was prejudice, and that clearly wasn't argued. Okay, so I think that's very clear that that's not preserved and not a basis to reverse upon. Then you have the second argument of compliance versus substantial compliance. Now, their memo argues that the letter complies. It doesn't ask for a substantial compliance argument. It doesn't ask for a substantial compliance analysis. And as someone who's done this more than anyone on earth, I can tell you that was asked for many times in these cases. Many times before Malam, before Busquets, lenders were asking for a substantial compliance analysis. That didn't happen here. When you don't ask for a substantial compliance analysis, the court can't be said to have gotten it wrong. They didn't ask the court to apply a substantial compliance analysis. So when you don't ask the court to apply a substantial compliance analysis, you can't go to the appellate court and say, you got it wrong because you didn't apply that substantial compliance analysis that I never even asked you to apply.
Mr. Stover, the procedural posture of the case below was what? Motion to dismiss and our motion for summary judgment hearing?
Correct. And this is something that I've done frequently because there's Florida Supreme Court precedent that says a defendant can move for summary judgment at any time, including before filing an answer. So we sought summary judgment, the remedy being dismissal of the case.